Great pleasure to introduce to you today Jaco Hamman from Hahn Hahn and Associates. For those of you that know Janusz Lutzerik, you'll know that they are both partners in crime at Hahn Hahn, which is a boutique law firm in Pretoria. Jaco is going to be talking to us about which is really contract law. And I'm sure he'll be able to tell us a little bit more about himself before he starts the presentation. Please, Jaco, so that everybody knows a little bit about who you are and what you enjoy doing when it comes to the legal profession. As I said, it's the very first time that we are hosting Jaco, and we really look forward to many more webinars in the future. Jaco, I'm going to hand it over to you. Would you like to take us away? Your presentation being force majeure. What will you do if you cannot supply due to COVID-19? Thank you, Jaco. Over to you.
Yes, good afternoon. Thank you very much, and thanks for the opportunity as well. Just a bit of background from myself. I'm a Free State boykie. Originally, I come from Bloemfontein. I studied law there, and I did my articles and got admitted as an attorney, and then I initially got an opportunity to work at the old PricewaterhouseCoopers in forensic accounting, and then I did a master's degree in forensic accounting and did some forensic accounting and auditing for 4 years, but then realized the reality is just that I'm just a lawyer. So, and that's my passion. That's what I do. So I think it's now about 10 years ago, I joined Hahn Hahn Attorneys, and my focus is on still a bit of forensics, and it gives you a nice sort of broader field at looking at things, because you've got the auditing and accounting and then the law as well. And then I focus on contract law and commercial and construction and labor and that sort of thing. So there's a couple of areas that we're looking at, and we've got commercial clients as well, and me and Janusz work a lot together as well. So yeah, so thanks for the opportunity. Okay, the question today is, what will you do if you can't supply due to COVID-19? Now, if we go to the next, Linda, just check quickly here. Sorry.
There we go. We're moving. All good. Move it back up one slide. There. Perfect.
Yeah, okay, so let's just quickly look at the agenda for today's discussion. Looks like a long list, but we're going to try and make it as interesting as possible for you guys. We're going to have a brief introduction, then we're going to look at contractual obligations, the common law and supervening impossibility. Now, that might now sound like a lot of big words, but don't worry about that. I'll take you through that. It's not that difficult. Then we'll look at the national state of the disaster and the legislation relating thereto, and then the actual effect of the COVID-19 on your business operation, so we can discuss that. And then damages suffered, who to blame and from whom to claim, we'll discuss that. And then moving forward,
yeah,
forward, and then the conclusion, and then questions. And like Linda said, if there's questions in between, please interact with us, and we will gladly, I will assist you on those and the questions as best as possible. Okay, so introduction. In order to answer today's question, there are basically 4 things that you need to consider. And the first one is your contract. Now, if you work with any IT person, or if you're in a company and you've got an IT person, if you phone that IT person and tell them you've got a problem, the first thing that all of them do is tell you or ask you whether you've restarted your computer, because miraculously that fixes everything. Now, if you ask a lawyer or tell a lawyer that you've got a problem, the first thing he is asking you and should ask you is, what does your contract say? Therefore, what I do before I phone my IT guy is I restart my computer first, so that he doesn't have to tell me I need to go and do it. Now, in order to save costs and times, whenever you have a problem, the first thing you need to do is go and read your contract. Now, with today, I'm going to assist you a bit to go and look at your own contract, so that you sort of have an idea before, and then one can determine whether you need an attorney or not, but then you can have some sort of idea. Then the next thing, what we need to answer the question is the common law and supervening impossibility, and then the Disaster Management Act and the regulations, and then as well the actual effect on your business or your ability to perform. So that's how we answer today's question. Now, when we looked at contract, now the purpose of a contract is to lay down the terms on which the parties wish to engage with one another. So contracts cater for all sorts of eventualities that the parties can think of, and then how each party is obligated to act or then react upon the occurring of that specific eventuality. Now, the terms of the contract are put simply, if you want to take it as basics as possible, that's the law between parties that they have chosen. So this is now the law that the parties chose when they entered into the contract with one another to say, well, how will they act upon the happening of an event? So because of that, that is why it's so utterly important for you to read the contract and understand your contract that you have. Now, most supplier contracts, although they are similar in nature, they are also unique, because you can have a contract that the essence of it looks exactly the same, but the force majeure clause, those differ. And then in fact, it's those differences that's very important. Now, I'm going to take you through some examples of these clauses. Now, some contracts do make provision for force majeure events. Sorry, this jumped. Okay, there we go. Some contracts make provision for similar situations that our country is in. Now, what I've done is I've not copy and pasted the clause as is, because it's very long and it's long-winded and that sort of thing. So and there's a reason for that, of course, and I'll get to that now. But I've shortened it so that it's a bit more understandable. So if the clause says, if you are prevented from carrying out your obligations by reasons of legislation, government interference, now that etc. would normally not stand in the contract. That's my own inclusion there for purposes of this presentation. So it will say legislation, government interference, act of God, such as floods and then riots, and then they call that the force majeure event. Then what does the clause say? It says that you will be relieved of your obligations, but you must inform the other party in writing. Now, it's very important when you go and read your contract to first go through the headings and see whether there's a force majeure clause in there, and then in there read it and then determine whether or not or what forms part of the force majeure events. Now, you'll see that in this one it talks about legislation and government interference. Now, this specific clause will cater for where you're not able to perform due to the act and the regulations, because this clause makes provision for that. However, what is very important is the fact that it says, but you must inform the other party in writing. That means that you can only rely on this clause if you inform your counterpart, the other contracting party, in writing, to say that I am prevented from carrying out my obligations, and therefore I am invoking my force majeure clause. Now, you don't necessarily need to use the words invoking my force majeure clause and that sort of thing. In essence, all you need to do is you need to put in writing and send it off to them in record of that, say that I can't perform in terms of my contractual obligations. Why can't I perform? Because of the legislation and the government interference into my actions. And then you can rely on this clause. Now, another type of clause that we've got is that, so the contract then does make makes provision for a force majeure event. However, the wording differs slightly, because in this clause, and let's read it together, it says, neither party shall be liable for failure to perform its obligations under this contract if such failure results from circumstances beyond the party's control, and then it lists wars and hostilities, acts of God, such as fire, flood, etc., and then that's the force majeure event. But you will note that in here, it didn't state change of legislation. Now, there's case law to the fact that that says that when you interpret a force majeure clause and you look at what is listed, that does not give you examples of what a force majeure event will be. It gives you the definitive list of which of these occurrences are in fact force majeure events, which will mean that if your current situation that you are in is not listed in there, it means that there isn't a force majeure event. And then further, what it means is that you can't rely on the contract to say, well, therefore, in terms of the contract, I am not breaching the contract. Because remember, if you don't deliver, if you don't supply, if in terms of the contract you were supposed to supply, let's take argument's sake, 1,000 boxes of Smarties. But if you didn't supply 1,000 boxes of Smarties, you're in breach of contract. Now, these clauses state that in these instances, you won't be in breach of contract. Now, if you're not in breach of contract, then it means you can't be held liable for any damages that somebody has suffered because you weren't in breach of the contract. But if the contract doesn't make provision for it specifically, then you don't have, on a contractual basis, you can't place reliance on it. Now, that's why if I go now to my next slide is, well, so let me just explain to you what the force majeure clause is regarded as. So, or elaborate on my explanation. So a force majeure clause is a suspensive condition. Now, what a suspensive condition means is it means that the contract is suspended as a result of a happening of a certain event. Now, once that force majeure event has come to an end and performance then becomes possible again, then the contract will continue. So it's only for that duration of the force majeure event. Now, where things can become very tricky and from a legal point of view interesting is to say that after the lockdown, let's say now the lockdown has now been stopped, and for argument's sake, the pandemic for that matter in South Africa has stopped. But that won't necessarily mean that you can now suddenly get all the products or the components of what you need in order to make your product. For argument's sake, I've got a friend that works at, let me not get into details what it is, but the essence of it is to say that if they can't start up now, because they're not part of the essential services, if they don't start up their machinery now, even on the 1st of May, if they then start, it's going to take them 2 months in order to be sort of start ready. So that doesn't mean that on the 1st of May, they can go ahead and they can produce. It's going to then already take them 2 months to sort of start off then again. So although the pandemic might have stopped, and although the regulations and the act and the working of that might have stopped, that wouldn't necessarily mean that the effect of it hasn't stopped. And therefore, that's one of the reasons why we get to the other one is the real question is what is the impact on your operations, on your business of this and how that carries forward. So in that one we'll have to look at per detail. Now, the last point there on this slide says force majeure clause is unique in that it makes provision for time to assess the outcome of the event instead of giving effect to the contractual consequences such as termination. Now, when interpreting your contract, read carefully and also consider whether it's the pandemic or the regulations that's the cause, like I said earlier. Another tip that I can give you when reading a contract or any legal document for that matter, or legislation, that sort of thing, is break it up in piecemeal. So let's say for argument's sake, you've got because lawyers, they love to write sentences that it looks like actually 10 paragraphs or 1 page, and then when you try and find the full stop, you say, see, the full stop is only at the end of the page. It makes it very difficult to read.
You said it. We didn't say it, so you said it.
And we try our best in our firm to remember that always and try to use full stops a lot more on that whenever we can to make it as easy as possible. But so what you do is when you're reading it, break it up word for word in sentences and portions, and then first understand that specific portion. And then once you understand that portion of the sentence, then move on to the next portion of the sentence. So dissect it, if you will. Dissect the whole thing into little bits and pieces. Then it becomes easier to read and to understand. And just remember, another thing is that you should never be afraid to ask an attorney. Don't think that the attorney will think that you are now stupid and that you're supposed to know all that sort of things. Rather, just ask them. They won't think you're stupid. On the contrary, it might make them feel like they are now very clever because they know something that you might not do. So rather just ask them. Now, as discussed earlier, some contracts won't have or do not have force majeure clauses, and some contracts that do have force majeure clauses don't fall within your specific situation. Now, the question then, of course, becomes, so what now? Now, this is where the common law and supervening impossibility comes in. Now, the common law, if I can just explain that to you, if we can start there, that in South Africa, it's just not just written laws. For example, now the Disaster Management Act, that is part of our law. We've also got what we call the common law. Now, the common law is a law that's not made of Parliament or any other lawmaking body, but through basically the judges and Roman Dutch law and English law. So it's things that have been passed on from generation to generation. For argument's sake, murder isn't a statutory, there's no written law that says, you won't find the Act 6 of 67 that says you're not allowed to kill somebody else. But it's a common law offense. It's part of our law. So that's what common law is. So if you, well, in this fact, the contract can't assist you, then the common law is something that you can go back to. Now, in our common law, we've got something that we call the supervening impossibility principle. Now, that applies after a contract was validly entered into. What this means is that the contract first needs to be valid. You can't have an invalid contract and then try to apply this principle of supervening impossibility. Now, if I put everything sort of into one small box to understand it, just say, so if you don't have a force majeure clause in the contract, you're going to rely on supervening impossibility. That's what you're going to do. So the next point is to say that if performance in terms of your contract becomes objectively impossible, now through no fault of either of the parties, now that's the very important part of this, is to say that I'm not able to deliver, I can't supply. However, it's not due to my fault. And it's also not due to the fault of the other party. It's not because, let's say for argument's sake, you've now got perishable food. Let's take a simple example, milk. Now, that milk, because it will go down, has to be accepted by the customer by a certain date. Now, if he's not open and you therefore can't deliver it because he can't accept it, then you weren't able to supply, but that was because of his fault. Now, supervening impossibility comes from when it's objectively impossible and through the fault of no fault of either of the parties. Okay. Let's go. So if it is impossible for the supplier to supply goods, the customer can't hold the supplier liable for any of the damages suffered. Now, of course, that is something that is good to hear and to understand, that if there is for some reason that you aren't able to supply it, then at least he can't hold you liable. It also means that you, however, won't be able to hold the customer liable for your damages that you have suffered. So, and we'll get to that a bit later in any event when we talk about the damages. The one thing though is just that you need to remember is that if you use supervening impossibility, that in effect will mean that the contract is terminated. It doesn't mean that you can't later enter into a new contract, but it means that for purposes of now, the contract has been terminated, and for the simple reason is that you're not possible to supply it. And if something is impossible to do, then it's impossible to do, then there's nothing to it. However, what is important to know further to that is that this impossibility, you've heard that I said a couple of times objectively. Now, the reason for that is that somebody from the outside needs to look in and say, yes, it is physically impossible for you to supply the specific goods, for argument's sake. Let's take now a simple example just for the moment of a non-essential service. If somebody produces a non-essential service, it is an impossibility for him, an objectively impossible thing for him to deliver. Why? Because the Act says he's not allowed to produce and deliver and to supply. Therefore, it's objectively speaking impossible. However, let's say it becomes more cumbersome or isn't as economically viable as it used to be to supply under these conditions. That doesn't mean that it's objectively impossible. Because let's take another example. Let's say your contract does not provide for the fluctuation of the rand dollar for exchange rate and that sort of thing. Let's say and I mean a lot of contracts don't provide for that. Then if the exchange rate changes and you now suddenly need to buy raw materials at a lot higher price, but you're in terms of the contract not allowed to change the selling price, that doesn't now mean that you're entitled to get out of the contract. You still have to produce and you still have to sell at that amount, because the contract says you have to deliver X number of products and this is what the customer is going to pay for them, irrespective of what happens at the back. Now, similar with this, if due to the pandemic, your situation has changed, it makes it a bit more cumbersome, that won't be regarded as an event that you can use and then say, specifically now, if we're talking in terms of the common law, that now you aren't able to supply anymore. Now, if your contract does make provision for force majeure, then again, you need to go back to the contract and go and read that carefully to determine what sort of thing needs to be in there. Now, under the contract, when you're entering into a contract the next time or looking at drafting a contract, that sort of thing, remember, and I mean, I've got clients that, the one specific client that I've known for 15 years now, he's one of my most dangerous clients, and the only reason for is he never reads his contract. He said that's why he pays. No matter how many times I tell him that there's nobody that knows his business like he does, therefore he has to read it. He says to me, well, we've known each other now, well, it's not 15, it's 10 years actually when I started this on. He says, you know my business for 10 years. I do know his business for 10 years, but I don't know his contract in and out or his business in and out like he does. So what you need to consider the next time that you're looking at the contract is also to try and think of eventualities or things that might happen that you've seen over the past happen to you, and then include that in your contract as well so that you can cover for that eventuality. Okay, the net, yeah, so let's move on to the national state of disaster. Like you all know, on the 15th of March, a national state of disaster was declared, and that was declared in terms of the Disaster Management Act. And then on the 25th of March, the regulations were published under the Act, and a national lockdown was promulgated on the 26th of March. and then of course it was later extended. Now, in terms of that, I know, no, go on track. Okay, so in terms of those regulations, movement of individuals are restricted, and as you know, only essential goods and services may be produced or delivered. Now, Annexure B of the regulation set out what is regarded as essential goods and services during the lockdown. Now, I'm just going to go through those with you. I take it that a lot of you have already gone through these things, but that's another thing is that go and read. There's no substitute for reading something. Go and read the stuff. It's available. If you don't have it, pop me an email and I'll send it through to you so that you can have a look at that. And not necessarily just because of the question, because you'll already know by now whether you are essential good or services. However, where in the chain, do you know whether somebody within your chain knows whether they are part of the essential goods or services? For argument's sake, pest control. I saw the morning again, I saw that with one of the last updates, pest control is also part of the essential goods and services. Now, the question is now, does the pest control guys know that they are part of the essential goods and services? Because if they don't, they're not delivering those services, then you might have other problems along the line further on. So that's why it's also important to read through these things. Now, the first thing, of course, when we talk about the goods is food. Any food product, including non-alcoholic beverages. Now, what's interesting about this is then, and one of the ways that you read legislation is to say, and a contract as well. The problem is contracts sometimes is just they fall very much short of the requirements. However, is you go and look at the definitions. So me, when I first read the regulations and it said food, any food product, I went back and I said, well, let's look at the definition of what do they define as the food product. But unfortunately, and I'm guessing that it might as well be due to the haste in which these things needed to be written, there is no definition for a food product. Nothing. So I think on this one, the way that one can interpret it and the way that the courts will interpret it is as wide as possible. Now, I agree with Janusz that when he said in his webinar earlier this morning that the biggest problem is the police and not necessarily what the legislation require or the people there on the street, how they interpret that. But that being said, the reality is, yes, although a police officer can stop you now and say, well, this is what I believe, at the end of the day, if we have to run to court to stop them and correct it, at least then we know that, well, we believe that we are in the right in moving forward. So there you can see the other one is animal food. Just one thing interesting on the food product is that, and again with the roasted chicken example that Janusz gave for the other participants, Janusz, my partner, gave an example of somebody that got arrested. I can't recall in which retail store, but never mind, for selling roasted chicken. Now, I had a look at that to see, well, that roasted chicken will still be a food product. And there isn't a prohibition to say that you're not allowed to sell ready-made meals that I could find. All it says is that when it comes to prohibition is that the restaurant needs to be closed. Now, if the retailer sells his roasted chicken out of the normal shop, whether that legislatively speaking then falls foul of this, that remains to be seen. But yeah, interesting time. Okay, there you can see the 3 chemicals, packaging, and ancillary products used in the production. Then we've got cleaning and hygiene products. The lists are there, the toilet paper and hand sanitizer, and of course your disinfectants and soaps. And then we've got chemicals, packaging, and ancillary products used in the production of any food product, which in your guys' case will be very important. Products for the care of babies and toddlers. Next line. And then we've got medical. This is now, remember, all essential goods that we're still with. So there we've got our chemicals, packaging and ancillary products, fuel, including coal, wood and gas, and then basic goods, including airtime, electricity, and the withdrawal of cash. Then we've got Annexure B, services. Now, the production and sale of the goods listed in category A is regarded as an essential service. So the production and sale of, and then the list is quite extensive. I'll send that through to you guys as well. I see that we are halfway through a lot of time. So I'm not going to go through the other services because I really would like to take some questions from you guys and engage in a bit in that. So
yeah, that would be great. Thanks, Jaco. That will be super. We'll pass it on to all the delegates. You can continue.
Pleasure. So it is, however, important to determine which services or good you are not allowed to supply in terms of the regulations, so that you know that you don't fall foul of those. Right. Now, the actual effect of the COVID-19 on your business operations. Now, the effect on each contract should be measured objectively, like we spoke earlier. Now, in order to determine the effect on each contract, because it is unique, you have to go and sit and look at it objectively, like I said. So the effect, however, must be that the performance has become impossible. Now, we've already touched on this bit earlier. Now, we know that the lockdown will have less of an effect on the supplier of medical masks, for argument's sake, or you guys in the food, than on somebody of a non-essential items. Now, of course, this doesn't necessarily mean that in the production of the food products that will go without its challenges, and maybe some of you guys can take us through that when we get there. But again, you need to remember and think of this and say, well, if now you can't deliver, go through your chain and go and see exactly what is the reason for that. Is the effect there of the pandemic? Is the effect, or the reason rather, is the reason the pandemic? Is the reason the lockdown regulations? And then one tackles it from that point of view in order to see what the real reason for that. Okay, next slide. That discussed. And yes, and I've touched on earlier that the profitability and the practically more difficult, then it doesn't mean that it's objectively impossible. What did I do now?
I think you can take it back one more.
Okay, yeah, there we go, yeah. Damages suffered, who to blame and from whom to claim. Now, the first question, of course, is that if you're not able to supply, or if something else happened, is what is your actual damages that you have suffered that you need to look at. And then whether anybody is to blame for the damages suffered. Now, this is very important because if, like we spoke about earlier, pertaining to the common law and as well as in your contract in any event, is that if you're not able to supply, however, it's not due to your fault or anybody else's fault, then in that instance you won't be able to claim. And the upside, of course, is that they also won't be able to claim. However, and when Janusz spoke this morning about the requirements from his slides and that, it sparked another thing with me that I realized to say that in the production of the food, and well, anybody in this stages, you need to be very careful that you comply with each of the requirements, the parameters that the government has set within which you are allowed to operate. Because if you get shut down because you acted outside of those parameters, then the fact that you can't supply, you can blame somebody. They can blame you. And that will then mean that you've breached your contract. Now, if you have breached your contract, that's going to mean that they'll be entitled to claim damages, to terminate your agreement, and all the other things that comes along with the breach of the contract. So you need to be very sure that you understand and know the parameters within which you are allowed to operate, and then stay within those, because you won't be able to claim the pandemic or the regulations if you can't supply, but however you were shut down due to your own fault. So for argument's sake, if there's let's see, well, let's say in order to produce food, your requirement is to say that everybody needs to wear masks and there has to be hand sanitizer, whatever the case may be, and you haven't done that. Now, because you haven't done that, now there's an outbreak within your facility and now it closes down. It's going to be very difficult for you to say that you weren't to blame, because you didn't follow the specific requirements and you didn't operate within the parameters. Now, where you will be able to claim money in any event is, let's now say, either you rely on the common law to terminate the contract, or you rely on the clauses within your contract to suspend the providing of services or to supply certain goods, but you have already supplied certain of the goods. Now, either the contract will make provision for what you should do in those circumstances, otherwise you'll claim that portion that you've delivered, you'll claim back, and that you'll claim back on enrichment principles. We won't get into the details of enrichment now. That's a discussion on its own. Moving forward. Now, this is sort of part of our ethos in our firm, and yeah, we feel very strongly about this, is that business solution versus legal solution. Now, the reality is a lot of our clients and people come to us and then they've got a business problem, and then they want to try and see if they can't find a legal solution for it. If you've got a business problem, don't look for a legal solution and run to your lawyers. Find a business solution to sort out the problem, because that's at the end of the day that you need to do. Therefore, communicate with your customers and your contracting parties. So the best route is definitely to not try and fix everything with the law. Speak to people, think objectively. How are we going to sort this problem out? Communicate with your customers, because remember that at the end of the day, this pandemic will pass. But your relationship, you need to remain that and keep that open. My apologies.
No problem.
Okay. So, conclusions. What have we discussed this afternoon? We've said, what is the things that you need to consider? You need to go back to your contract to see what your contract says. Now, yes, I've just said that you need to look at a business solution and not a legal solution. However, if you don't know the playing field in which you need to operate, i.e., what does your contract say, then you're also going to struggle to find a business solution in any event. So go and read your contract. Your contract doesn't make provision for force majeure. Look at supervening impossibility, your common law. Look at the regulations and other legislation that might have an impact. And then, of course, don't objectively look at the effects and the reasons. And then the possibility of claiming damages if you suffered damages. And then lastly, moving forward. And then I want to, before we go to the questions, leave you with this saying from Marcus Aurelius that says that if you are distressed by anything external, the pain is not due to the thing itself, but your estimate of it. And this you have the power to revoke at any moment. So yeah, you can't change the situation, but you can change the way that you see it and that way you react.
Absolutely,
right.
Absolutely. Very, very interesting, and I'm just thinking through so many different options in terms of, you know, the impact that this could have on many different food companies, you know, just as a result of not having supply and you know, those kinds of real problems. Just an example, Jaco, you mentioned some examples, or rather, if we could talk about some examples from the food industry. So Tiger Brands announced in the media last week that they were, to quote the article, living from hand to mouth when it came to the supply of rice, due to the fact that this would be imported product from, you know, other countries where there is also a shortage. In that case, we are definitely getting to the kind of situation where a force majeure would apply.
Yes. Now again, the first question on that will be is the contract that Tiger Brands has. Does that in there? How does that stipulate? Does that on the one hand make provision for something like the change of legislation and that sort of thing, or for the pandemic itself? So there again, you have to specifically look at the words of the contract, and then if it doesn't make provision for that, go back to the common law, which in this instance would mean that it is a physical impossibility for them to produce because they're not getting the volumes of the rice. Because also, although the ports are open for the rice to come in, it's not as if it is business as usual. So the volumes that you're getting is going to be less, and therefore the volumes of your output is going to be different. So although you can partially perform, you still can't perform in terms of the contract.
Yes.
Now, for that purposes, again, it will be best to say, well, okay, this is the situation that I'm in, and then go and speak to your customer and have a sort of interim amendment to the contract, so that you don't sit with the later situation that there is unclarity of what each party expected from another. Because one of the other things that I've realized over the years is because the way that a customer sends me a contract, then I read it briefly through, sort of glance over it. Before I say anything to the client, I ask him, what does he want the contract to say, and then what does he think the contract says? And almost 99% of the time, that which the contract says isn't what the client thinks. Now, it's not because there's somebody that's trying to be now underhanded or whatever the case may be, but one of the things that most often happen is I've got an idea in my head what I think we've agreed, and you've got a total separate idea, but we both believe that we're on the same page, but we're actually not.
Yes.
And that's where the fighting starts.
Yes.
So now you are saying to your customer that I will supply you as and when I get, let's take the rice, but you've got 10 customers. So you say to each of them the same thing. Now, some of those customers believe that you will give all the rice that you're getting, you will utilize towards their product. And they're not thinking to say, well, you remember this guy has 10. So now what he does is he makes promises again to his clients based on the fact that he now calculates this is the number of rice that's going to come in, this and that. Now suddenly there's a confusion of who said what, and that's where the fighting starts.
Yes, no, absolutely, and I think it possibly has something to do with the fact that you lawyers don't use enough full stops. No, I'm just kidding, but I think when it comes to understanding, the requirements, it is important to make sure that there is clarity of understanding in terms of both contracting parties. You made an important statement, and I know you didn't discuss it specifically, but maybe you can just highlight what would constitute a valid versus an invalid contract, because you made the point that you may or may not have the force majeure clause within your contract, but the contract must be a valid contract if the clause is in your contract. What would constitute an invalid contract?
An invalid contract will be, for example, when the performance is already impossible prior to the actual delivery of it. So that would be an invalid contract. So the impossibility has already started even before the signing of a contract.
Okay.
Yeah.
All right.
Yeah.
So the contract must. Yes, no, it does.
Yeah.
No, definitely. And I know there's other, technical requirements that must be in a contract for it to be valid. But I think what you're saying here specifically is I can't quickly go and put a contract in place now with my customer that happens to have a force majeure clause, which I'm going to invoke next week because I can't supply. That's not, we're already in the state of disaster. It would not be in good faith in that respect.
Yeah, and I mean, if you can't deliver something, then you can't. I mean, you can't for example, you can't give away more rights than something that you do have. So for argument's sake, I can't tell somebody that, I can't even think about now, that I will provide him with, let's say, okay, let's take an example of an office block. So I've got a office block, however, that office block in there's a certain space in there that I don't own. Now I can't rent that out to somebody else. That contract will be invalid because I'm not the owner of that flat. I don't have any rights which I can then pass on to somebody else. Of course, now there's some other consequences because of my actions, that if the person has now suffered damages due to the fact that I made as if I were able to rent it out to him, but that's something totally different. Then it's a delictual action. That's a topic for another day. So, but for the purpose of this, that would be an invalid contract because you don't have the rights.
Yes. Okay. Sorry. Continue.
The other thing that I'm thinking of now is like me and you discussed briefly offline, is some of my clients that's not necessarily in the food industry, but the optometrists, that they are now renting office space in big shopping centers. Now, one of the questions there that we're busy considering, of course, is to say that optometrist isn't allowed to operate at the moment. She's renting a business premises, and the reason she's renting that business premises is for the purpose of having customers to come in. Now, of course, she can't utilize that premises at the moment, not at all. So they've got no customers coming. Now, the question there again is to say, well, what do you do in those circumstances? Now, the first thing, like always, go back to what does your contract say with the landlord, and but in any event, that's also something for another day.
So one of your colleagues would like to know, what about the principle of good faith? So in the relationship between the contracting parties, negotiating and renegotiating contracts during COVID-19 and lockdown, obviously, I think you did mention the fact that you don't want to put yourself in a worse position for after lockdown, but I think you've also said that it may be necessary, and you should rather take the route of at least talking and possibly renegotiating some of the requirements even during the pandemic and lockdown.
Yeah, you see, the thing of good faith is that it's very important that in order to get to an end solution, that parties do discuss and relook at these contracts on good faith. However, in certain instances, you're going to have parties that's not going to be doing it in sort of good faith. Or, again, the question is, in whose mind this person is not acting in good faith? Because that's another thing. Because remember, if you want to say that in terms of the contract, because you've got these clauses in a lot of contracts that says that the parties endeavor to act in good faith and always try and see if they can't reach an agreement and that sort of thing. Now, the first question on that is to say that if you're saying that the other guy is not acting in good faith, the question is not whether you believe he's not acting in good faith, whether objectively speaking he's not acting in good faith. Because that specific other contracting party has, again, his own obligations and his own other sort of subsequent contracts that he needs to fulfill and that sort of thing. So regarding the question of good faith, the first thing will be, is that person in fact acting in good faith or not? Now, then the next thing, let's say you are able to prove that this person isn't acting in good faith. Now, for me, the problem is whether you're going to get a judge that's going to say, well, this person, when you renegotiated the contract or when you looked at the contract, wasn't willing to act in good faith, therefore he's now breached the contract because he's supposed to act in good faith. But yes, he might be breaching the contract, but that won't be a reason for terminating the contract. So, yeah, I don't really see the effect of those things if people don't act in good faith from a legal point of view. That, of course. But then again, if and this comes back to the whole thing, trying to find a business solution with your other contracting partner, with your problem. And speak to that person together, find a business solution.
Yes, yes, absolutely. Okay, now you picked up on an interesting word when you started the list of services, and that products, goods rather, and that being food. And the fact that we don't have the definition of food. And so I think Antoinette is making a comment more than anything else, and that is in relation to quick service restaurants. So I think there's been a concern when it comes to quick service restaurants. I think all restaurants in that fact, from that fact, because obviously they supply food. So why have they been excluded from the as essential goods? The example that Janusz raised this morning about the deli within the retailer selling the chicken and being closed down by the cops. Why are these things happening? Because the definition, or rather the regulation, just says food, and surely these are still food requirements. Antoinette's comment is in relation to, would that broad definition not mean, technically speaking, that quick service restaurants could actually be able to continue trading, providing they are using the correct PPE and applying the correct, physical distancing?
At the moment, they can't, because of the way that Antoinette has described it. So she's already described it as a restaurant, and a restaurant is specifically excluded.
Yes.
So
yes.
Now, and there's two different ways albeit from a legal point of view, to look at these things. The first thing is to say, what am I allowed to do or not allowed to do? So in this instance, the quick service restaurant's not allowed to operate because, the definition, I haven't specifically looked at the definition of a restaurant, but if we all talk about it as a restaurant and then as a quick service restaurant, it means it's a restaurant for our purposes, and therefore you can't. So, but then the next question is, because remember, it's not, although the regulations are there, it doesn't mean that you aren't able to fight the regulations.
Sure.
And that doesn't mean you're not able to. And then you have to go and have a look and say, well, okay, so now they are busy infringing our rights that we do have, which of course in certain instances is fine, but is there a valid reason for it, and then where it comes from? Now, if you think about it, is that if the scientist tells us that and the doctors and all those clever people tells us that the food can't be produced through the virus can't go in the food, that's something different. Now the question then would be, of course, to say, well, then why won't you be allowed for these food restaurants, these fast service food restaurants, to go and home deliver? Why not do that? It might be something different. Say that you're not allowed to have a full restaurant due to the fact that social distancing, and now what happens is you've got those people camped in there. However, again, the question is to say, well, if you look at the drive-through, what is the difference from a medical point of view and social distancing point of view versus the number of people that you've got there working there in that fast food restaurant, and they're using the drive-through? I mean, the reality is the only person that you are interacting with is the person that's actually serving you the food, which is exactly the same within a retail. So there might be something there for the fast food guys to have open up discussions and then see if the government comes to the party and then go to court.
Yes, absolutely, and I think I mean, just in the media, last week there was something, an article from the Restaurant Association specifically in relation to this, because all the arguments that you've mentioned seem perfectly logical from a risk perspective. And I had an interesting discussion with Janusz in this respect, and again, I'm definitely not a lawyer, but he did mention something which I thought possibly had to be considered, and that is that at this point in time, lockdown means stay home and stay safe. Would opening restaurants, put us in a position where the act of staying at home is now, we're almost working against that principle that, in order to flatten the curve, we have to stay home. And by opening too many restaurants, we would, even if it is for takeaways, I'm still leaving my home. And is that going against the principle of the lockdown completely? But no. I think in terms of home delivery, possibly that, that's a slightly different aspect. But he mentioned the word, or rather the phrase, what is the mischief that the law is intended to curb? And, I suppose from that perspective, there may be another side to this argument, but I think it will be one that will go to court. Because I think that there's growing debate in this regard. I have a question here from Ashley. Ashley asks the fact that you have case law that provides you with the list of circumstances that is included in a force majeure clause, but that doesn't necessarily give you an all-inclusive list. Obviously, there may be examples that are covered by case law, but that's not necessarily an all-inclusive list. What if the wording of your clause is written in a broad manner and includes any circumstances that are out of either party's control? Would that be enforceable? Would that clause be enforceable, or does it actually need to specify events? Or would the event need to have been specified by case law? I hope I'm understanding the question correctly.
Yeah. So this is where those commas and ands and full stops and things become very, very, very important.
Yes,
I mean, we once had a fight over a comma that the legal fees was R1 million about what the meaning of comma was in between the sentence of where it sat. So, and that's why in this instance, if it is drafted broadly, the interpretation of those words will be very important. So the question will be, is it really drafted broadly because the parties are trying to cater for some eventuality that none of them could think of? If that is the interpretation of it, then one will be able to fit it in here. Then one, it comes down to what the meeting of the mind. So what is it that the parties agreed to? So if you can say that the parties had agreed that, look, we're not sure and we're not going to even try and think of something, but if you are able to prove that this is something that none of us could think about, then we will let it fall under the force majeure clause. Okay. Then you'll do it like that. But again, the wording of that contract and that paragraph is very important.
Absolutely, absolutely. Jaco, thank you so much. I've learned a lot. I really have. I think there are huge implications for many companies, food companies. Although we are considered essential goods and the delivery of food is considered essential services, I think, as you've highlighted, there may be events that are as a result of the regulation and the pandemic that are outside of our control. And the first thing we have to do after this is we have to go and read our contracts. I hope everybody got that as homework. Please go and find your contract with your customer, with your suppliers, and make sure that you read the contract. because you need to understand the possible implications around this clause if you have it. And if not, I would suggest that you look at the last slide, because the last slide is going to give you the contact information for our presenter. And I would suggest that if you have any further questions, please, you need to make sure that you are contacting Jaco in this respect, because I think this is, there may be other technical aspects that you would want to pose to him, and it would be worthwhile getting an opinion, I think, if you are not 100% sure. Jaco, thank you so much. It's been very, very interesting. Thank you for your time, and thank you for the effort that you put into today's presentation.
It's a big pleasure, Linda. Thank you, and all the best, and keep safe, everybody.
Thank you. Have a great afternoon, everyone. We'll see you next week.